court is calling 2024 CR 009-218 and 2024 009-219, State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
And for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say, my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waived your right to appeal.
Waived the right to appeal means this is basically locked in unless something extremely unusual happens later. That's why plea deals are serious. You're trading your trial rights for certainty.
I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community.
Therapeutic community inside prison is a structured rehab program. It's the court basically saying you're doing the time, but we're trying to reduce the chance you come out worse. And the phrase affirmative finding of a deadly weapon is important too. That label can change parole eligibility and future consequences, even after release.
The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This run concurrent with 2024 CR 009218. There's to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have a combat ribbon. So that was erroneous.
Okay.
Step number two, it shows there were two priors of misdemeanors. There was only one. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you. Is there anything else from either side?
Well, Judge, I don't know if Mr. Sherman wanted to bring this to your attention, but because the defendant is going to be in custody, I did see that he filed motions to remove the ignition and the lock. Your motions to.
Yes, she's already signed.
Okay,
Yes, I signed those,
no
yes.
objection to that.
All right, thank you.
And then we do have victim impact, but
Victim impact statements are not about proving guilt anymore. Guilt is already decided. This is about the human cost. And in courtrooms, this is often the moment where everyone realizes this case isn't paperwork, it's permanent loss.
All right, so who are the people here for victim impact?
there's the father,
Okay,
well, the father and husband of the victims, and then the daughter and sister.
all right, so everyone, just give us a moment. We're gonna have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can give your victim impact. Court is calling 2020-23 CR 10366 State versus Claudel Dwayne Corney. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Good morning, for the defense?
Christopher Ramos for the defense.
And are you Mr. Carney?
Yes, ma'am, this is me.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Ms. Boyd.
Are you the same Claudel Dwayne?
Yes, ma'am.
All right, are you the same Claudel Dwayne Carney who was placed on deferred adjudication in 2023 CR 10366 for the offense of aggravated robbery on February 13, 2024 for a period of 10 years? Is that you?
Yes, ma'am, that's correct.
All right, state.
Yes, Your Honor, violation of condition number 41. On or about the 8th day of September 2025 in Bexar County, Texas, the defendant, Claudel Dwayne Carney, did then and there fail to register for, attend a moral recognition therapy program with an approved agency in violation of condition number 41.
All right, if we could go off the record for a moment, I don't have a violation of condition number 41. Is that in a supplemental?
No, Your Honor, it's the original UTR.
All right. To the violation, how do you plead, true or not true?
True, ma'am.
State will waive the other two violations, Your Honor.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, find you guilty, and sentence you up to life in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, Your Honor.
Court will find violation of condition number 41 true.
The court already gave him a chance with deferred adjudication, but when you plead true to a violation, you're basically handing the judge the key to revoke you and sentence you like you were convicted from day one. This is why probation conditions are not suggestions, they're traps if you don't stay on top of them.
Is there a proposed agreement?
There's not, Your Honor. Both state and defense are going to make the recommendations to Your Honor.
All right, state, what are you requesting?
Before I make my argument, Your Honor, I ask the court to take judicial notice of the court's file.
All right. What specifically do you want the court? I know you say the court's file, but is there something specifically?
The facts of the underlying offense and his history on probation. as
All
well.
right. You may proceed.
Thank you, Your Honor. We're here for the defendant's motion on this aggravated robbery charge that he is on probation for, and Your Honor is aware of the facts of this case, being that he initially stole that victim's phone, ran away with it. The victim was lucky enough to later find him at a gas station close by, and when the victim asked for his phone back, the defendant pulls a knife on him and says, "Come and take it. Come and get it." With a deadly weapon, he threatened someone's life, therefore being placed on probation, for 10 years. We're here on the second MTR this defendant has had within the last 4 months. For same violations as it was just 4 months ago in June, Your Honor, where the defendant had a new number one that we unfortunately had to waive. That victim was his sister. He assaulted her. She did not want to come in to support that day.
Well, you
I
have-
would
all
strongly
object.
right, that objection will be sustained. If it was waived,
Okay.
then it will be sustained.
We reluctantly had to waive number one today. We were ready to proceed on the contested MTR yesterday. Victim here, sister here, to testify about what he did to her. They decided not to show up today. Therefore, we had to proceed on the technical violation of condition number 41.
Well, I
Given-
mean, if you would like, my understanding that there would be no objections. If they would like to zoom in, I was going to say it was working.
Formally, Judge, I don't remember, for the benefit of the record and on behalf of my client, I would have to object on their appearance on Zoom. I would ask them to appear in person.
Okay. All right, you may continue.
Only because of the defendant not coming yesterday, we were unable to proceed with trying to prove the assault that he committed against his sister on September the 4th, 2025.
Okay.
As such, because of the underlying offense, because of his history, because he had the opportunity that Your Honor gave him back in June to go to Louisiana like he requested, but instead chooses to commit new crimes, they feel that he is not an appropriate candidate for probation. He should be revoked. He should be adjudicated guilty. There should be an affirmative finding of deadly weapon. State is seeking that Your Honor sentence to the 10 years TDC.
All right, defense, you may proceed.
Specifically to speak to him not registering or attending the moral recognition treatment course. My understanding is that he failed to, at least the date alleged, is a date in September of 2025. As he describes to me, he was released from jail in July of 2025. And he does admit to me that he did not register for the class. And part of that where he was struggling was a combination of him dealing with, as the court may be aware of, some of his mental health struggles that he's dealing with. He reports to me that he is schizoaffective, dealing with bipolar. I believe probation has some information about that. And he was also struggling with transportation. At this moment in time, in September, I think he was just struggling to function as an individual, he's just struggling to function. But I would ask the court to be mindful that while on probation, as far as I can tell, he's completed some of the outpatient requirements. He's completed anger management. There were a series of events where he tested for substances and he came back a series of times negative. He's been to DDRF, and when I ask him about his experiences there, he's able to recite their philosophy, the things that he learned. He's describing that he learned strategies on avoiding conflict, on what his triggers are. And other than this allegation of assault and a minor relapse with the substance, I think he's doing the best that he can. I think he was living in a household that was pretty volatile. And I think he's living with other individuals that struggle with them. They struggle in terms of how to deal with his mental health issues, and it's a bad recipe.
Mhm.
I have a sense that he's doing his best. He describes to me he wants to fight the new #1 as it exists on its own because it's a new case. So we are respectfully asking the court to continue him on probation with some sort of jail sanction, and to be mindful that he has given his mental health, he's doing his best to accommodate, that's the wrong word, to fulfill the agreement he's made for probation. So for that, Judge, we're asking for you to continue him.
All right, probation.
We have his probation officer here as well. We're going to like to hear from him.
No, I mean, what is the recommendation?
Oh, Judge, so what's listed on the court summary is DDRF followed by 6 months sober living at approved location, and ISP supervision upon DDRF, bi-weekly UAs for 60 days post DDRF. He did complete DDRF 121 days. He completed an outpatient program. He completed an anger management program. He has not completed the moral recognition therapy, the referral for Center for Healthcare Services. His last UA in August of 2025 was positive for amphetamines. And his last office visit with his officer was in August of 2025.
All right,
And I'm thinking that's because maybe that's after that his respiratory taken hold.
okay. So here's the thing, Mr. Carney,
Yes, ma'am.
I don't think you're appropriate for probation. I granted your application over the objection of the state,
Yes, ma'am.
and I can only do so much. What the court is going to do is the court is going to find violation of condition number 41 as previously stated. The court is going to sentence you to 6 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. There's an affirmative finding of deadly weapon. The court will give you credit for any time served for successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am. I don't want to say that you're moving too fast, Miss Boyd.
Judge.
No.
Miss,
Well, that's fine. You can call me Miss Boyd.
my principal in Shelby Middle name was Mr. Boyd.
Okay.
Ma'am, I get it. I just came home November 1st and consistently back in your courtroom, and I am ashamed. Also, ma'am, the new class that you signed me up for, told me to go to, I didn't have no transportation. I didn't have no kind of ride. I'm getting kicked out of this house that my brother had owned, caught a heart attack in, and they had multiple individuals in there. I haven't even spoke my mind about what's going on in this house, from guns, drugs activity, and Center for Healthcare helped me, got my food stamps. Just one of the two same sisters are stealing my food stamps. Those are triggers that I learned. So I removed myself from that household consistently. But I always went back because you know why? That's where I probate to. That was my original
No,
house.
so here's the thing. I
Yes,
tell
ma'am.
everyone who's on probation in this court, if there's an issue, all you have to do is let probation know about it.
I did, Miss Boyd,
Mhm.
and also I was trying to tell you, like, recently, I just cleared a $25,000 lawsuit.
Mhm.
Only thing I did for myself, ma'am, was buy a brand new car. It was $12,000. It's in New Orleans. My niece was driving it to me the day that I got locked up, ma'am. Consistently, if the system, I'm not gonna say the system failed me. I, I love Mr. Alcantara, my probation officer. I wish he could speak up on my behalf.
Mhm.
Ma'am, no, and I just moved back to San Antonio because I just recently found out in 2023 I have a 12-year-old baby that I didn't know that I did not know I was even.
So here's my question. Why didn't you contact probation and say all of this was going on in your life?
I tried, Miss Boyd. I really
I know.
did. Because I was in jail. I didn't know not one, but two of my siblings passed away.
Mhm.
One of them overdosed from drugs. And
So here's the thing, what I want you to internalize.
yes, ma'am.
This is what I want you to internalize. I took into consideration your mental health issues
Yes,
when
ma'am.
I granted your application for deferred. And I granted that application for deferred over the objections of the state. So what that means is you need to be on what's called your P's and Q's and make sure that you're doing everything that you're supposed to be doing. And
Yes.
you're not. So
And-
I just don't think you're appropriate for probation. So I'm
Okay.
not going to continue you.
Yes, ma'am. All right. And but Mr. Alcantara, I can have a peaceful word with Mr. Alcantara before I leave
For
the
what
courtroom.
purpose?
Because he could tell you some of the things that I was going through before I got locked up, ma'am. I was explaining the stuff that you said that I wasn't explaining to probation.
Mhm.
I was explaining to Mr. Alcantara. I knew it was going to be. I didn't know how it was going to happen, but I knew it was going to happen. I was going to fall off. Ma'am, I just bought this car. I didn't have no transportation to make the last class, and I was going to complete the last class. I even much have the money right now to pay off my whole probation. I just didn't. It's it's the people that was around me, man. My family did not want to see me make it. I have all my probation fines and fees, the whole 7,000.
Oh, here's the thing. Your attorney can address with you whether or not you should be spending money to pay that because you're no longer on probation. That would be money that
So I
Yeah.
to do 6 years, Miss Boyd.
you'll get credit for any time that has
You
been
could tell
served.
me how much time served that do I
To the
have?
clerk, can you look up how
120.
much time?
And what about the credit for time served the last time when I was?
You'll get credit for any time that you've been in custody on this case, even prior to being placed on probation. Did you review the trial court certification of defendants' rights to appeal? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion.
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Ms. Boyd.
All right,
Thank you.
thank you. You're welcome.